Welcome back, everybody. My name is Tom Olsen. The name of the show is Olsen on Law, every Saturday at 11 a.m. right here on News Talk WDBO. My guest today is attorney Rob Solomon, and we are taking landlord-tenant questions for him. Rob, one question I want to handle is security deposits. Let's assume that there's been a landlord-tenant relationship. The lease has come to an end. Everybody's done what they're supposed to do. What is the process for the landlord and the tenant for the return of the security deposit?
Okay, so a security deposit is there for, it's not a piggy bank for the landlord. It's there at the end of the lease, just as you've described, and it becomes the landlord's responsibility to take the first step. And so the landlord has to give a notice if he's making a claim on the security deposit, or he has to return the security deposit. The way the statute is written is he either has to give the security deposit back within 15 days or send a notice as to why he's not giving it back within 30 days. That's kind of a mystifying clause that our legislature came up with. So I tell landlords, be conservative, do everything within 15 days. You're either making the claim on it or you're not making a claim on it. You're either returning it or you're not within 15 days by a certified letter to the last known address or the new address, if you know where your tenants have gone to. It then becomes the tenant's responsibility within 15 days of receipt of that to object to it. If he doesn't object to it, there is a waiver of the claim to the security deposit, and the landlord can use it. And likewise, if the landlord fails to do his responsibilities within the necessary time period, he loses his right to it. So this whole process is designed to either create the claim or to waive the claim. And so that's the process. If everybody does their job and a waiver is not made by either of them, this money is supposed to stay put until it is resolved by a small claims court.
And how often, when it goes to small claims court, are there attorney's fees in that situation?
There are attorney's fees. All of landlord-tenant law is covered by a provision that gives the prevailing party attorney's fees. And this is particularly when it comes to security deposits. Very often the case is a question of, did somebody not follow the proper procedure? So it's sometimes very easy to determine who's right and who's wrong in a security deposit case.
Very good. Appreciate it, Rob.